My name is Armando Ortega, and I'm the Director of Product Marketing at Replicon. For those of you who aren't familiar, Replicon is the leader in cloud-based time tracking applications. We do have over 7,800 customers worldwide and address many different types of time tracking needs, including time and attendance and labor compliance. And today, Replicon is very excited to present the webinar on our topic of recording work time. And we're very pleased to have Brian Dixon of Littler Law Firm join us here today to present the webinar. This is actually the third of a 6-webinar series on compliance. Last month, Brian delivered a great webinar on the topic of understanding work time and gave attendees guidance on how to determine when someone actually is on the clock and whether or not they should be paid. Now, once an organization has figured out when someone should be paid, this webinar is really tackling what's the best way to go about recording that work time. And it might be simple at first glance, but it's actually more complicated when you start looking at the details. But we're fortunate to have Brian here today to help us sort through all of that. So before we get started, though, I'd like to take just a few minutes to go over a few housekeeping items. First, let me inform you on how you can participate in today's webinar. During the webinar, you'll be kept on mute, but you can submit your questions at any time using the Q&A box at the right-hand side. So you can do that at any time during the presentation, and then your questions will be addressed at the end of the webinar. This webinar will be recorded, and we will have a copy of the presentation available also for those who would like one. The second point is I'd like to remind everyone that you are eligible to receive HRCI credit for attending this webinar. And you will be receiving a copy of this presentation, as I mentioned, and just follow the instructions here on the slide. You will be receiving an email with the certification information. You do need to stay on for the complete webinar in order to receive credit. So now, let me go ahead and introduce today's speaker, and we can get started with our presentation. So I'm very pleased to introduce to you Brian Dixon today. Mr. Dixon is a shareholder in Littler's San Francisco office and co-chair of the firm's nationwide wage and hour practice group. Mr. Dixon is a graduate of the Stanford University School of Law and has served on a wage board for the California's Industrial Welfare Commission. Mr. Dixon provides a full range of counsel and representation with respect to employment and labor matters. His particular expertise is disputes regarding minimum wages, overtime, prevailing wages, and incentive compensation. Mr. Dixon is the author of the Federal Wage and Hour Laws, published by Shoreham, and the general editor of the Wage and Hour Answer Book. He is a contributing author to the Fair Labor Standards Act and Wage and Hour Laws, a state-by-state survey published by the ABA, and California Wage and Hour Law and Litigation, published by the California Bar Association. So without further ado, what I'd like to do is hand it over to Brian and have him walk you through the presentation. Thank you, Brian, for joining us today.
And thank you, Armando, for your introduction. And let me say it's always a pleasure to work with you and all of your colleagues there at Replicon in providing record-keeping, cloud-based record-keeping solutions for what are some a challenging workforce which is ever more mobile and ever more in need of record-keeping. And, of course, we want to realize that today's discussion is in many regards a summary, simply because the subject of wage and hour is both broad and deep. And we want to make sure that the information that's provided is, of course, verified to be applicable to you, particularly as an employer, as we have many employers on the phone from across the United States, on the program from across the United States, and record-keeping obligations, like all wage and hour obligations, vary from state to state, always with the umbrella of federal law above us. Today we're going to talk about what is the basic record-keeping obligation, what additional record-keeping issues do meals and rest periods pose, what are best practices for signing and editing time records, record-keeping for and about exempt employees, and what do I do when I get a request for time records. Recording work time is an essential aspect of paying employees appropriately, paying in particularly non-exempt employees appropriately, because we have to track hours for overtime pay purposes. And there's a group of employees known as partially exempt employees, which we'll talk about briefly. Those are employees who may, provided certain conditions are met, be overtime exempt, but we still have to track hours for them. Basic responsibility is you need to have an accurate record of what an employee, non-exempt employees' hours of work are. Federal rule regarding record keeping is very simple. You can simply have a record of the total number of hours worked per day. You don't need, under federal law, a record of the clock time at which an employee begins and ends each period of work, but we want to be aware that we are bookended by Connecticut and California, two states which require that we record the clock times when each work period begins and ends. Whose responsibility is it to keep a record of work time? They all suspect correctly that it's our responsibility. It is, in fact, our responsibility, and it's a non-delegable responsibility in the sense that, sure, you can ask an employee to keep a record of his or her hours of work, but, in fact, if you do so, you do so at the risk that if an employee doesn't keep an accurate record, you are not relieved of responsibility by virtue of the employee's failure to do so. The largest and smallest consequences of this rule are you reach the end of a pay period, payroll calls up and says, hey, we don't have a time card for X, and you're thinking, well, if he or she isn't interested enough to submit a time card, maybe we're not interested enough to cut a paycheck, but we want to remember that the obligation to record hours of work is non-delegable, and that means that you have to coach payroll into calling the supervisor and figuring out to the best of your ability what hours did this employee work, pay those hours, and then follow up after that to figure out what else might have to be paid. The largest consequence of the rule that recording work time is a non-delegable obligation is that if you don't have an accurate record, you will bear the burden of disproving what an employee's hours of work are. So if, for example, you have an employee who works out of site, perhaps because they work in the field doing repair work, service work, or perhaps sales, and you don't have a record of their hours of work and they're a non-exempt employee, they claim overtime. They say, I worked a gazillion hours. It's never less than a gazillion hours. You bear the burden of disproving that, and that can be nearly impossible if you don't keep an accurate record in the first instance. So we want to be aware that keeping a record is particularly important. So let's go on and look at our next slide and talk about rounding hours of work. How accurate does a record of hours of work have to be? And there is no rule as to exactly how accurate the record has to be. It's really defined by what you can't do, as many things in life are defined. And you can't, for example, round excessively, and we'll talk about rounding work time. And you can't omit small amounts of time unless they are truly de minimis, and we'll talk about de minimis time as well. One common question is, can I facilitate this entire process, make it even more convenient to employees by using a pre-populated time card, for example, a time card that is filled in with the employee's schedule in advance? And yes, you can do so, but we always have to be sensitive to the too perfect time card. When I and my colleagues look at the time cards in a new wage dispute, the first thing that we look for are realistic variations in work time. There are very few employees who are so perfect as to arrive at 8, leave for lunch at 12, come back from lunch at 1, and leave work at 5 every day of the year, 365 days, or excuse me, 260 work days in a year. But you'd be surprised how often we see that, which of course is a red flag that the record isn't accurate. And a pre-populated time card is an invitation for a time record to be inaccurate, so I would be very cautious in using a pre-populated time card. Next question is, can we round work time? And yes, we can round work time, but we want to realize that rounding grew up in a period of time back in 1938 when the federal overtime law was first passed, when we didn't have smartphones, we didn't have laptops, we didn't have desktops, we didn't have mainframes, and rounding time was in many regards an essential way in order to compute the time for all the employees in a large facility and get them paid. We now have the benefit of those resources, and I'd have to say that I don't see any reason other than to pay employees by the minute. Rounding is a little bit of an archaic practice. It is a practice that often leads to lawsuits, and quite frankly, when I talk to employers about why they round time, too often the answer is, well, it saves us some money because it works to shrink the number of hours we have to pay for. And of course, we can't use it as that device. The basic rule regarding rounding is that you can round time, But the employer and the employee have to share equal burden and benefit of that rounding. For example, if you round to the nearest quarter hour, you round up from 7 minutes before the hour to the top of the hour, and you round back from 7 minutes after the hour to the top of the hour. Employers get in trouble in rounding if the rounding interval is too large. In rounding to a half hour, the maximum permissible interval is a quarter of an hour. Or, for example, the rounding doesn't correspond with when the workday starts. You round to the hour, quarter hour, half hour, three-quarters hour, but you ask everyone to be in for a shift change meeting 5 minutes before the hour, your rounding is going to systematically exclude some work time. The other thing is we want to remember that employees have to get the benefit and the burden of rounding. And I have a hotel client which was recently surprised when it received from corporate headquarters a new handbook which said you're considered tardy only if you're more than 7 minutes late. And we happened to be chatting about it, and I said, well, the answer to that really is simply this, and that is the benefit and burden rule. You can't enforce a we'll discipline you if you're 1 minute late rule if you're going to round, because that means you get all the benefit of rounding up from 7 minutes before the hour to the top of the hour, and the employee doesn't get the benefit of the opposite. One regard in which this sometimes sticks out a bit is leaving early. And a rounding rule, technically, if you round to the nearest quarter hour, would allow employees to leave their workstations a little bit early on occasion and punch out, a few minutes before the hour and be rounded up to the hour at the end of the day, increasing their pay. And few employers really want to tolerate that. So if tardiness is an important issue for you and staying to the end of the shift is an important issue, rounding is not your solution. The other thing that we want to be aware of is in the about half dozen states that require rest periods based upon usually a formula. California has a formula, Washington has a formula, Colorado has a formula. Those are precisely tied to the number of minutes someone works, and rounding can conceal when an additional rest period might be due. Same issue with respect to meal periods, particularly those states that are stringent in enforcing meal period obligations, such as Oregon, Connecticut, California, New York, where if you round your meal period entries, conceivably somebody might have a 17-minute meal period, but with those extra 2 minutes there, it rounds up to the top of the hour. And the half hour, it looks like you got a half-hour meal period when you did not. So you particularly don't want to round meal periods. One other thing that we want to be aware of is that and we'll talk about this in a little more detail, is record keeping for meal periods and rest periods in Washington and California is particularly important because of the additional pay that can be due an employee. And it's always helpful if you are using an electronic time system to have a system that is sufficiently sophisticated that it provides exception messages or notifications when an employee is approaching or exceeding their meal period threshold or their rest period threshold. There are amazing things you can accomplish with technology in record keeping today. The other major limiter in terms of when do we record or when do we have to record work time is de minimis time, and there is that famous legal chestnut to the effect that the law doesn't bother itself with trifles, and de minimis time has been around for quite a while. We want to be sensitive to the fact that as time has gone on, what is de minimis has shrunk, in part because our ability to record keep accurately has grown. And de minimis time is measured by the duration. Certainly a few minutes of time is a lot more de minimis than a quarter of an hour, by the frequency or repetitiveness with respect to which the activity occurs, and the administrative difficulty in recording the work time. We want to be sensitive to the fact that this becomes an issue very frequently in a call center where someone may have to log in, have to go through a login process before the system automatically records their work time at the end of the login process. It could also be an issue for a non-exempt employee who's expected to check his or her email remotely on a BlackBerry or Sharp smartphone late in the evening. And one, of course, the every morning login has the constant repetition. It may, depending upon the speed of the network and login process could be 2, 3, 5 minutes. We want to be sensitive to the fact that the Department of Labor takes the position that any consistently performed activity cannot be considered de minimis. Now, not every court would agree with that, but we do want to be sensitive to the fact, and we do want to be sensitive to the fact that plaintiffs' lawyers and class actions target call centers that have repetitive processes, or any other employer that has a repetitive process that is not recorded as work time. We also want to be sensitive to the fact that de minimis time can become an issue with respect to, for example, a walking time. If an employee has to perform what otherwise looks like a small activity, perhaps in a locker room, and then walks to their workstation and logs in at the workstation, the risk of the de minimis time triggering the start of the workday and that walking time becoming working time is very great. And if you look at the many recent court decisions regarding changing into uniforms, the focal point often is not just the changing time, it's the fact that the workday has begun, and then the travel from the changing area to the work area becomes work time, and what looks like a few minutes of time in dispute suddenly becomes 15 or so, and you multiply that across the workforce, and then we have a major issue. We also see that in security check cases where, for example, do you have to go through a security check before you enter a secure workplace, such as an airport, or a bag check in a retail environment where, for security purposes and to minimize shrinkage, the employer performs a bag check at the end of the day. People have to stand in line. The time in the line begins to grow as the shift change occurs, and then all of a sudden you have an issue as to whether that time is de minimis or not. And employees who work at airports where there's security for everybody, passengers, members of the public, employees who work at the airport, perhaps construction crews that go to the airport to work, security check has by and large not been found to be work time. The bag check, unfortunately, has become an issue recently, or more of an issue recently, in a case where the plaintiff, Busk, worked at a warehouse, was actually paid by a staffing company, employed by a staffing company to work at an warehouse that helped service Amazon. That case has now gone up on review to the Supreme Court, so we want to keep an eye on security check processes. Let's go on and talk about meals. And where do I have to record the starting and ending times of meals? Well, you have to record it in California and Connecticut, as we discussed. Those are the two states that require you to record the exact clock times, but certainly the best practice is to record clock times for all employees. You're going to get a much better record, a much more accurate record, a record that's much less likely to lead to a dispute if you do have a record. And my personal experience is that if you use some sort of time recording mechanism, be it a time clock or a login process that is automated, you get a more accurate record and you have fewer off-the-clock claims than if you simply use paper time cards. It's much easier. I don't think I've ever had a off-the-clock case that involved an appreciable amount of work when an employee was actually using a time clock. There's actually a little bit of respect there for the mechanism. What if somebody punches in early at the end of the meal? Do we have potential liability there? Well, you do. A meal period basic rule has to be 30 minutes long in order to be non-work time. That's true under federal law. It's true under the laws of all the states that regulate meal periods except Illinois, which recognizes a 20-minute meal period. What can I do to avoid that? Because, of course, you can, for example, in Oregon, be penalized for providing short meal periods, as well as in other states. About 12 to 15 states regulate meal periods, the specific provision of meal periods. And so some employers use a lockout feature on the time clock, which is that basically prevents an employee from clocking back in to return to work at the end of that meal period. We have to, of course, every solution has its own problem. I had a case a little while ago where the employer had a lockout feature in order to prevent employees from returning early from meals. and of course we got an off-the-clock claim on the basis that I still had to go back to work. I just couldn't punch back in at the end of my meal period until that 30 minutes had gone by. One common practice that you see across the United States is an auto deduct for meals, and it is legal to have an auto deduct for meals, but it's often problematic. I was on a panel recently with some plaintiffs' counsel discussing wage and hour obligations, and the plaintiffs' counsel, their question came from the audience, is it lawful to have an auto deduct process? And plaintiffs' counsel responded, yes, it is, but it's an invitation for a class action. And an auto deduct, of course, is simply that the employer presumes the meal period was provided, the deduction of half an hour of time is made, or an hour, or however long the meal period is. The important thing, the essential thing, is that there be an exception process that an employee can readily use and is not discouraged from using when an employee's meal period is too short or otherwise limited, such that it has to be considered work time. Here in California, of course, the Golden State, golden for any of a variety of reasons. Some is that we have some very well-to-do plaintiffs' lawyers in the state, which are constantly monitoring employers' wage and hour practices. We know after the Brinker decision, the famous decision about meal periods, that an employee can waive a meal period as long as the employer provides the meal period and in a timely fashion, and that is before an employee works 5 hours, and again before an employee works 10 hours, the employer has to provide the opportunity to take a half-hour off-duty meal period during which the employee is relieved of all duty, is not interrupted, and is free to leave the premises. The state pays a very high premium on meal periods, obviously. If you don't provide the opportunity to take the meal period, you have to pay an extra hour of pay premium at the employee's regular rate of pay. And of course, in the state where most employees are driving to work, probably having a cup of coffee, holding a muffin in the other hand and talking on the cell phone with their kids, you might think that the meal period in the middle of the day is important simply because it doesn't appear to be acquired either before or after work. In any event, an employee has to be provided the opportunity to take the meal, but need not actually, the employer doesn't have to ensure that the employee takes the meal. The employer doesn't have to, quote, kick the employee out, close quote, the door in order to take the meal. The thing that is a challenge, of course, is how do we document that? And you can, in California, have an advance waiver of meal periods, but, an advance waiver of anything is very problematic. No one knows what the future holds, and that waiver, which might have been gladly signed under a beneficent supervisor who took good care of his or her subordinates, might be viewed less validly or might be even revoked by an employee in a short conversation with a supervisor at a later point in time. So using blanket advance waivers is problematic. Your time recording system has to have some mechanism for an employee to say, I took all my meal periods, or I waived them with the exception of the following that I missed, or have some mechanism whereby an employee can record missed meal periods, and at the end of each pay period, and again, I think it's appropriate at the end of each pay period, for the employee to say, I received the opportunity to take all my meals and took them except for those that I recorded as missed. So you can use one of two processes there to ensure that you have that. And it's, again, very important that you do that on an ongoing basis. There's always the challenge with an employee, quote, turning around some 4 years later and saying, I never really got to take any of my meal periods over the last 4 years, and there are roughly 260 work days in a year, maybe 250 if you take the holidays out. And you look back 4 years, that's 1,000 hours, that's 6 months of pay. And I want my 1 hour pay premium for that. So your fundamental rule is, regardless of the Brinker decision, the best evidence that meal periods were provided is that they were regularly taken and accurately recorded. Let's go on and talk about rest periods. Here in California, of course, you can have potential liability for a 1 hour of pay if a rest period isn't provided. We want to realize that Washington State is equally strict, and if you miss a rest period in Washington Washington, the employer actually has to pay an additional 10 minutes of pay, and those 10 minutes are counted as work time, and they can trigger the obligation to pay overtime. So California and Washington are hotspots for compliance here. There are about half a dozen other states that regulate rest periods, and of course you can receive the civil penalty or some other citation if you don't comply with the state's labor laws, and obtaining some certification that rest periods was provided is important in those states as well. The challenge, of course, is what do I want to do here? Do I want to have a record where an employee runs to the time clock every time they take a rest period? Particularly a challenge in Washington, which allows rest periods to be taken incrementally, 2 minutes on the phone to the youngest daughter, 2 minutes on the phone to the middle son, 3 minutes on the phone to the eldest daughter, and 5 minutes at the water cooler can be a rest period in Washington, not so here in California, of course. How do I record that? And if you require employees to record rest periods, you run the risk of creating a negative record, and that is that employees will inevitably fall off of that repetitive chore, and you're best off just obtaining, again, a certification or attestation that all rest periods were taken. And if we can go on and take a look at our next subject here, we'll talk about mobile employees and some of the challenges they pose. Of course, as we have more and more workforce that's spread out, especially a workforce that moves around, sales, service, deliveries, installations, we can have the challenge in the sense that we may see the employee only in the morning and in the afternoon, and how do we capture that meal period, particularly for an employee who is self-motivated and may want to hustle through the day and leave work with everything done a half an hour before the time otherwise would run for the day. We need to be very careful about mobile employees. The fact that record keeping is difficult doesn't mean that we're excused from the obligation to keep that record. So if nothing else, we need to have an employee fill in a paper record when they return to the shop or the yard or the office or the factory that they in fact took their meal period and when did they take it. Or we need an app on an iPhone perhaps that allows us in a more sophisticated fashion to check that time. Auto deducts, again, are permissible, but they're hazardous. You really want to make sure that you have a good exception process in place. And in today's world where hustle is the rule, that would be a challenge, I think, if you were to auto deduct for mobile employees. And our next subject is correcting time cards. And when we think about correcting time cards, we might start with the basic question, can we in fact do so? Or is the time card inviolate in some sense, not violet in the color, but inviolate in the sense that it can't be violated? And certainly your obligation is to keep an accurate record of the hours worked. If the record submitted by the employee is inaccurate, you are actually obligated to correct it, but we need to be careful of process here. When the Department of Labor conducts audits these days, for example, they will ask, do you have an electronic timekeeping system, and do you have, quote, an audit trail in it, which of course is a record of whether any of the entries were changed, and you need to have a robust audit trail if the entry is changed. More important, the supervisor has to engage with the employee if a change is going to be made. If the employee is not accurately recording their work time, they are failing to perform one of their most important duties, and the supervisor wants to stay up with that, counsel and or discipline the employee as necessary in order to make sure that the time entries are appropriate. And that requires, of course, some documentation. Your audit trail should include space for a supervisor to explain why the change was made. In an ideal world, the supervisor should communicate, I think at a minimum, the supervisor has to communicate with the employee that the fact that a change is necessary, and in an ideal world, the employee would make that change, and the reason for the change would be documented. It's really helpful if, when you're monitoring electronic timekeeping records, where a supervisor might feel tempted, and I've had this as an issue with several employers, to change work time entries in order to meet the labor budget and look better in the eyes of upper management, you need to monitor your electronic timekeeping system very closely and either pull reports out of the timekeeping system as to which supervisors are making changes and how often they're making changes, or automate that process so that both HR and payroll receive reports of which supervisors are making changes and how frequently. If there are a lot of changes, you at a minimum have a supervisor that needs some help in how to train his or her subordinates. And at the outside, you might be wondering if all of those changes are appropriate. As we discussed before, and as we'll look at the next slide, there are partially exempt employees. The most common example of that is an inside sales employee, an employee who works at a retail or service business, is paid at least time and a half the minimum wage for each hour of work, and more than half their compensation is commissions. And that's a fairly common exemption. Most of the major department stores use that exemption to limit overtime costs. And of course, an employee who's a motivated salesperson will want to work more hours in order to earn more commissions. We want to realize, though, that accurate record keeping underlies that employee's compensation. Even if the employee is sufficiently successful, then you don't have a problem. You don't want to have a problem by not monitoring the hours of work and making sure that all the requirements of the exemption are met. Exempt employees, why would we keep time about exempt employees? And we'll come back to my major suspicion when an employer looks at timekeeping and exempt employees. The challenge, of course, is that in a case that was decided here in the Ninth Circuit some years ago involving Kern County, the Ninth Circuit in fairly broad terms said, well, an overtime exempt employee is really paid for the value of their managerial efforts and not really paid for their time, and suggested that record keeping for exempt employees, timekeeping, would be a bad idea. That has really eroded to the point of virtually disappearing as a premise, although in a close case about an employee's exempt status, the court might consider whether precise records of hours worked were kept. But today, you can keep a record of exempt employees' hours of work. As one court noted, you may well need that information to make staffing decisions. Another reason you may want that is if, for example, employees' time is billed to clients, you obviously need a record of hours of work. So you do want to be mindful of that. I am, I will say, somewhat cautious about recording the hours of work of exempt employees for two reasons. One is that if an employee comes back and challenges their overtime exempt status and says, I want to be paid for all of my overtime, and I've had that happen on a number of occasions, and you go and you look at the record of the employee's hours of work, and the supervisor says, darn, those really look quite exaggerated. No one here works that many hours. And of course, when I asked the manager, well, why didn't somebody say something about this record? And the manager's, well, you have to know that we're very busy and no one has the time really to spend looking at a record that really doesn't mean anything, because recording the exempt employee's hours of work isn't something that really drives what their pay is. And of course, it might drive sick leave and vacation, and we look at it for that reason. But I do have to say that keeping a record of exempt employees' hours of work is sometimes as problematic as it is helpful. One other observation I'd make is that when I have a client that is closely scrutinizing exempt employees' hours of work, it often does correspond with what the Ninth Circuit said, and that is that if, in fact, the number of hours an employee puts in is particularly important, it suggests that they're really engaged more in a production-type activity and less engaged in true exempt managerial, learned professional, or administrative work. So if you feel a strong temptation to keep track of a certain classification of employees' hours of work, I would I would also put on the to-do list, the infinitely long to-do list, it would be a good idea to double-check the exempt status of these employees and to see if their hours of work concern is really concealing a larger issue. And we have, responding to requests for time cards. we want to be aware that in California and a variety of other states, an employer is obligated to respond to requests for time cards, and that obligation has become more rigid and potentially broader here in California with recent amendments to Section 226 of the Labor Code. You are obligated within 21 days of a request to provide an employee's records. Then the question becomes, what are those records? And through some vague drafting by the legislature, the obligation to provide records has been expanded to records, quote, pertaining to their employment. And we've had quite a bit of go-round recently with plaintiffs' counsel as to whether that expands beyond simply payroll records. And even with respect to payroll records, we get a lot of assertions from plaintiffs' counsel these days that you have to show me the time cards as well as the payroll history, the history of what paychecks were provided. In the past, it's always been the case that a payroll history has been sufficient. So we want to keep an eye on both the timing and the scope of requests in that regard. And along the way, we have jumped over one subject that I'd like to briefly address, and that is signing time cards. Is there any obligation to sign a time card? And the answer is no. Again, the employer's obligation is simply stated as the fact that you have to keep an accurate record of an employee's hours of work. And that record need not even be kept by the employee. It could be kept by a timekeeper who in the previous years might be someone who sat at the factory gate and just wrote down when people came to work or left. In today's practice, it might be the foreman of a crew who writes down on a time card everyone's work time who's on the crew. And the question becomes, should I have, in addition to what we talked about in terms of meal periods and rest periods, a certification on a time card that the hours of work are correct? And certainly it is extremely helpful, and it is the best practice to have employees sign their time records and to review them before they are submitted to payroll. We want to make sure that if you have an electronic timekeeping system, those hours are either visible to the employee and the employee can review them and push a submit button so they go to payroll, or if your system doesn't allow that opportunity, you should be able to distribute a printout of the time records to employees, allow employees to review them, and sign a brief certification that says the record is complete and accurate and I have not performed any work off the clock, which I have failed to record here today. And of course, you want to combine that generally with, in those states where meal periods and rest periods are important, a certification that all meal periods and rest periods were duly recorded and noted in the time record. And thank you. With that, I'm going to, we'll be able to take questions in a few minutes here. I'm going to turn the program back over to Armando, and Armando can talk a little bit about some of the timekeeping solutions that Replicon provides.
Great. Thanks a lot, Brian, and thank you for a great presentation and a great overview. For everyone, please, this is a great time to start putting in your questions. If you have any questions, Brian will be here to answer and address those questions. Before we get to the Q&A and to give some folks some time to come up with questions, I'd like to take a few minutes to give people an overview of Replicon and the solutions that we offer to help organizations record their time more effectively. So Replicon is the leader in cloud time tracking applications, and our solutions are used by millions of users around the world to manage many different things, manage workforce attendance, which is the key topic that we're talking about today, but also other things such as keeping track of project time, managing professional services organizations, and we are also common in shared services organizations where people want to track time for the services that are delivered. Here's a quick snapshot of the customers that we have. Because we are a cloud solution, we can scale to meet the needs and requirements of very large organizations such as MetLife, Fujitsu, Xerox, but we also have a lot of smaller organizations that have a few employees, and because we are cloud, they can very easily deploy our solution. They don't need to require a large IT staff to maintain it. It's all very, very fast and very easy to do. All you need is a browser access the application. So it's a very good solution that works no matter what size of company you are or what industry you're in. And the customers that work with us, these are some of the main high-level benefits that they feel that they get by using our solutions. The first is around insight. So that's by being able to record time, whether it be for project purposes or just for time and attendance. It really gives organizations a better view into how employees are spending their time. And that can provide them a lot of insights into how to best manage them, understand where employees are spending their time, and how to best utilize them. The second that's very important is lowering the risk of compliance, which is what we're talking about here today. So whether it's for time and attendance or for DCAA compliance, if you're a government contractor, we provide a lot of capabilities that I'll go into more detail that help meet those compliant requirements, provide enough audit capabilities to be able to defend any kind of audits that organizations have to undergo. And then the third one is really speaking to the automation of the process. So using technology to take what used to be a manual process or used to be a process that relied on spreadsheets and putting it into technology that gives you all the benefits of technology that help you streamline, make that process faster, more efficient, give you access to it via other devices as well. And this is the core of our time and attendance solution. We do have other solutions for professional services organizations that want to keep track of time for billing or for project-based costing. But for time and attendance in particular, we have at the core our time tracking engine that makes it very easy for employers to roll out a way for employees to track their time. In addition to that, though, we offer absence management capability, so that allows full self-service time off requests as well as accruals. We support pretty much any type of time off, whether it's vacation, sick leave, jury duty, bereavement, whatever is required, and all the accruals happen automatically. We offer cloud-based time clock functionality, and so our time clocks allow organizations to very quickly and easily capture employee time by having employees just clock in and clock out, and scheduling support for organizations that need to drive schedules and manage that. And then compliance, which is what we'll talk a little bit more in the next couple of slides here. So having those capabilities to help address the compliance needs of organizations. So here's our philosophy with regards to time tracking with Replicon. So really, our view is that we provide a foundational way to track all employee time centrally. As I mentioned, we do this in the cloud, and we give our customers the ability to access that system from pretty much anywhere. They shouldn't be restricted by their device or location. Organizations, of course, should get to choose which of these they want to deploy, whether it's all of them or only some of them, and it's up to them. And so it's important to have mobile access, and I'll talk a little bit more about that. But as Brian was explaining in his presentation, we're in an increasingly mobile workforce, and being able to reach out to employees where they are is an important component of the solution. Of course, we have our standard web interface. So wherever employees are, they can log in through a browser and log in their time that way. We also support access through tablet devices, which are becoming a lot more prevalent in today's work life as well as personal life. And then time clock, as I mentioned before, we have a set of an approach for doing a cloud-based time clock solution where you take an ordinary tablet, apply an application that can transform it into a clock where you can clock in using a card. It takes a snapshot of the employee, and that snapshot also becomes as an effective way of having a facial recognition way to help address buddy punching. So I'll talk about a few of the capabilities before I jump into the Q&A here, but just a few things to highlight some of the things that our customers really like about our solution that some of you might find interesting as well. One is expanding a little bit on what we mean by a Replicon mobile device. So we support both iPhone and Android. And by giving this app, employees are able to enter their time and as well as their expenses. We also support expense management as a complementary solution for time and attendance. And they can basically enter their time from anywhere. We also offer them the ability to manage approvals. Managers can look at approvals, can approve timesheets remotely using their mobile phone if that's something that you want to do. I mentioned expense management capabilities. If you're wanting to do employee reimbursements, you can take a snapshot of the receipt, upload it into the system automatically, so that avoids having those lost receipts that you typically find. If you're wrapping up a lunch meeting, you can just take a snapshot of your lunch bill, and you're done with that part of the process. And then, of course, time-off requests are also supported by the mobile device, being able to submit time-offs and having managers approve those requests remotely. And this is a great tool that can be used whether you're in a cab, if you're traveling, or just not easily available to a computer. It really gives you that flexibility. Some of the other compliance capabilities, I have two more to go through. One is around the fact of having capabilities to ensure the integrity of the process. And so one is our timesheets are very configurable. So we have a lot of different clients from many different industries, and they want to capture information differently in a slightly different way. In-out type of capability is very common, where employees just click on a button and the system clocks in the exact time, and it doesn't allow any editing. Some employees do allow some editing. Employers do, and so we support that capability. Some employers prefer to do more of a duration type of time tracking, where they're actually having the employee just type in the number of hours they work. So regardless of the need, our solution is flexible to meet that specific requirement that customers have. Also, our workflows are an important component of keeping that compliance to ensure that managers are looking at that information and able to verify that the hours logged are accurate. And again, as I mentioned earlier, these can be approved in the system or through a mobile device. And the audit trail of timesheet changes that Brian also mentioned is a key component. So you can see here in the screenshot, we have full audit capabilities so that when a manager comes to make an approval, if there are any changes in the timesheet, they can see those changes, and the system can and will prompt employees, if you choose, to explain a reason for any changes or edits that were made, or only allow supervisors to make changes to the timesheet. So all of this is very flexible. We have audit trails that provide a complete listing of all the changes that were made in the timesheets. These are all very helpful capabilities, especially when you're asked by an audit to support and provide record keeping for all the information that you've done. And there are other compliance-related capabilities that I'll highlight here. This is just a sample. But others are really focused on reducing a lot of the violations or a lot of the policies that Brian talked about that some companies have. Whether you want to be able to track when an employee is in late or out late, we can track that. The system lets you configure and define what late means. What's the time period that defines a late entry. Meal break and rest period was something that Brian talked a lot about as well. So being able to track and document rest periods is an important part of the solution, as well as allowing for rounding support. So Brian, provided some good guidance on rounding and how to go about that and his point of view there. But if employers do want to do that, and we do run around organizations that do want to support rounding, we provide that as an option for employers to do that. So this is just a snapshot of some of the capabilities that our solution offers. And I hope this gives you a great overview of Replicon. Now, before we move into the Q&A here next, I just wanted to remind everyone that we do have 3 more webinars coming up in the lineup where Brian will be joining us again. And you can see the dates and the topics listed here. The next one is focused on minimum wage and related wage payment obligations. So that should be a great webinar coming up. And if you want more information, you can visit our site. If they're not posted there yet, they will be posted very soon. And if you are interested in viewing any of if this recording or any prior recordings of this webinar series, you can also access those at this link available.